the first question I want to know is, can this be resolved on a dispositive motion?
Mm-hmm.
And, you need a realistic answer to that. I mean, I've had attorneys file a motion for summary judgment without consulting with me. And when I ask them what the likelihood is, it's 10%. I'm like, why did you spend $15,000 for the likelihood of being successful at 10%? We can't.
And why did you file a motion without talking to me about it?
Oh, it's more than you think.
Welcome to The Defense Never Rests with Morgan Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. I'm your host, Megan, and today I'm joined by Melissa Schroeder. And I'm so excited to have Melissa on because her and I talked like months ago, and our scheduling just never worked out to get her on. And she followed up recently, and the stars aligned. So I'm so happy to have her on to talk about, her career and where she's been and where she's going. So with that, let's bring her in. Good morning, Melissa. Welcome to the Defense Never Rests. How are you today?
Good morning, Megan. I'm doing really good. How are you doing?
Great. I'm so happy to have you. You and I, we were just chatting about this. You and I had talked like back in October, November,
Yes.
And had planned on recording this then, and then just life got in the way. And so it kind of just didn't happen until now. But that's the beauty of this. Like, just because we talked back then doesn't mean we can't revisit now. And I'm so happy you're joining me today.
I'm really happy to be here.
Well, I know you've listened to this podcast, and for my listeners out there, I really like to get in and get to know my guests, so people listening can get to my guests. And the framework of this podcast is to talk to people in claims, about claims, but talk to attorneys who work on defense work. And we all have really unique paths in ways that we kind of got to where we are. And you started off as an attorney. You went to law school, and you still are an attorney. Not that you just ended and went to the side, but what was your, what was your path to law school? Was it something you had intended to do, or did it kind of, you ended up there because it was the best option for you at that time? Like, everyone approaches it a little bit differently. What was your approach?
When I got into college is when I really started taking a hard look at going to law school. I had a few different majors that were all aligned with a career in law. I started off with political science and then moved on to crime law and justice, but then ultimately decided on an English major just because I felt that would be beneficial, with writing briefs and motions and different things like that. So I always knew I wanted to go probably since my freshman year of college.
So you actually had like an idea of what law school is about, which is rare. Like the fact that you would know that there was like writing motions. I didn't know that. Like that was all stuff I kind of discovered.
Growing up, my father for a shelter for abused and battered women in Miami-Dade County, and then he moved on to the state level in Tallahassee, and he very frequently had to write grant proposals and try to get funding, and he worked very closely with a lot of different attorneys. So growing up, I was kind of exposed to various attorneys with various practices.
Yeah. Well, that's really good, like, experience to have going in, like, and having a better at least a better framework of what you might expect, at least in the real world. Because I do feel like a lot of times in law school, you don't really, unless you, at least at my school, unless you had the opportunity to do a clinic, like you're not really getting much practical experience in it. You had a little bit of that exposure early on.
Yes. And I did a clinic.
What did you do a clinic on?
It was an international law clinic. We basically argued for asylum rights for Tibetan individuals. And we would just go, and our teacher was pretty hands-off and just would try to just observe us in the background. And it was good because it was a good experience to get your feet wet, because once you establish that they are Tibetan, they're pretty much guaranteed asylum. So it was a good first impression for me in law.
I actually had a very similar type clinic, so like a similar experience, and and it was hard work too, but it felt very, like very rewarding to do as well.
Yes.
So, you know, everyone has, I think, differing opinions too about their like law school experience. Did you find your experience to be a positive one, or one that you would like recommend to someone else?
I definitely think it was gave me the opportunity to participate in the Frederick Douglass moot court. And then my last, when I was a three, was the like overseer of that for my school. And so I really enjoyed, the hands-on approach, and just and to know like my, now they're my colleagues, but my classmates at the time.
When you graduated, or actually when you were in school, did you have an idea of, the type of work you wanted to do?
I thought I was going to go into international law. I didn't ever think I was going to be in employment. I just kind of fell into it. But then once I fell into it, I really liked it.
Yeah. It's funny because I think we all have like these lofty dreams of like what we think we want to do. I think when I started law school, I was like, I wanted to be like a patent attorney because I had the science background, and I was like, okay, yeah, this is totally for me. And then when I was in law school, I realized like all these other, students who also wanted to go into patent law, like they had much stronger science background. So while like I had the credits that I could sit for the patent exam, I kind of knew that like my background wasn't strong enough to actually probably get me a job. I mean, maybe if I took the patent exam and passed, maybe that would make me pretty marketable. But I just knew, comparatively speaking, like, oh, well, this person has like a master's in like biomedical engineering. And I'm like, well, I had like a math major. Like,
Yeah.
so, you have to pivot and change your path a little bit. And, and that I think is also a continuing theme throughout our careers, is the ability to pivot. So when you graduated, though, you went into private practice in employment law.
Yes, I ended up a practitioner, Matthew Wolf, who is now a municipal court judge in Philadelphia. But he primarily focused on employment law, but it was general practice, so I was exposed to other different types of cases and stuff like that. But primarily, I focused on employment law.
And in your role working as an employment attorney, like what were some of the challenges that you had on your day-to-day handling, those cases and files? And we all have our challenges. So what were yours?
I think a big one was managing clients' expectations. Usually, when somebody has lost their job or feel like they're being discriminated at work, emotions are very high. And so plaintiffs would come in, and they would be very adamant that they didn't do anything wrong, or very adamant that they were discriminated against, and believe that they were entitled to very large sums of money. Because you hear on the news, somebody was sexually harassed and they got $1 million, but that's a very rare instance where you're going to get acknowledgement much, or a settlement for that much. So managing their expectations, I think, was primarily one of the more difficult things. And just and managing emotions.
Yeah. I mean, that is, it's managing emotions and expectations, and it can be the hardest thing to do, particularly like in your shoes, is, when you have clients who they feel very wronged and, violated, and, and their feelings are valid. You have to temper their expectations as to what those feelings equate to in the legal system.
Exactly. And that experience actually was really beneficial for when I went over to claims, because it can be the same thing with employers who feel that they did everything right, that they did not discriminate against this employee, and they just want to fight it tooth and nail. And especially if you're dealing with a smaller business or a small business owner, this is very personal to them. It's not the same as like a large corporation that's used to, getting charges and demands and lawsuits filed against it. So being able, like having early on in my career managing plaintiffs' expectations really helped me managing insured's expectations as well.
Yeah. And I talk about this a lot because, the small businesses, especially, litigation can be so disruptive to them because a lot of it, they take it personally, but also like it's not a common occurrence. So it's disruptive because it's new and it's different and it's unfamiliar. And, you have to kind of help them like walk through the process and make them feel comfortable with the process and that you got them, you got their back in this because it's a lot, whether it be an employment claim or, a personal injury claim or whatever it may be, it's very disruptive to the business.
Exactly. And also with, especially with small businesses, it seems like they have particular attorneys that they're used to, that they've worked with for a while. And that particular firm or attorney might not be well versed in employment law. They might be great at other things, but not employment law. And trying to navigate with the insured to have the best legal representation can also be complicated as well.
Yes. Yeah. And you kind of can sympathize to that too, because they're like, oh, well, I've used Johnny for years. I trust Johnny. I like Johnny. He knows me and he knows business, but Johnny doesn't know anything about employment. So like, yeah, if, someone was injured on your property, Johnny might be your go-to, or like
Exactly.
whatever that is very difficult to navigate. And you have to help that insured to build that trust up with this new counsel, who's helping them out with the the employment matter.
Exactly.
So what are some like in your role, or were there some tactics or strategies you use to help your insureds feel comfortable with the counsel if they were unfamiliar with them?
Yeah, I mean, usually with insurance companies, whether or not they have a panel counsel list or just attorneys that they frequently work with, there is a vetting process that we use to make sure that that firm appropriately knows, that they timely respond to communications, that they provide the best defense and not try to just take it all the way to trial only to settle it when it's not in the best interest of their client.
Mm-hmm.
And just explaining that to them and also giving them choices between various firms, let them know like these firms are the ones that I've worked with in Philadelphia. And I think X, Y, and Z is a great firm. But if you feel more comfortable with this firm, and give them a list of approved counsel and let them choose.
Yeah.
Have the choice to at least decide what firm that they want to go to. Because if they have a choice, they could, even if they have a counsel that they do like, they can always consult with that counsel, be like, hey, have you ever heard of this firm? Do you know, are they reputable? Do you like them? Do you suggest that I go with them? And so that can be helpful with just providing different options and different choices.
Absolutely. And it's there's so much of it is about like giving them the opportunity to choose and like come up with their own decisions, so they're not feel like someone's being just thrust upon them. So one thing that you and I had spoke about when we talked months ago was, the challenges of navigating so many claims at once. When you're in that claims manager position, like, you have a lot on your plate. So, how do you keep do you have like systems in place that, help you keep tabs on, all your files?
Well, I've utilized spreadsheets. Both insurers that I've worked with, do have a diary system within their claims handling system, which you can also utilize. I personally like just using Office and Outlook because I can sync it up to my phone. I can sync it up to Teams, and just it's very well structured and organized.
Yeah.
But everybody I know has a different preference on how they like to keep track of everything. I have certain colleagues that really rely on a spreadsheet, and that's their go-to, and others really, really rely on their calendar and setting reminders.
Yeah. Yeah. I'm like a combo of the two, and I think I've been told I have too many systems in place, but like I could probably simplify it a little bit. But what a and you've mentioned Philadelphia. Like I'm also based in Philadelphia, so I'm very familiar with the Philadelphia litigation landscape and the challenges that we see in our wonderful city. And so, what are some challenges that you've experienced with litigating claims, whether it be in Philadelphia or other jurisdictions, that kind of cause you litigation headaches?
Well, the location for one, and also it can be complicated as well if I don't have counsel that I'm familiar working with, and it's in a jurisdiction that I've just never dealt with. Like I had a claim one time in Billings, Montana, and I'm not well versed in Montana law. Luckily, we had a great firm on that, and we were able to get a very nice settlement at mediation. But just there's every state has its own legal system in place, and things can be extremely nuanced. And that's when I have to like heavily rely on defense counsel to provide me, the requisite information so that I can value the claim properly. So that I would say that could be one of the biggest headaches for me. And then also just not timely getting case assessments and budgets.
Mm-hmm. Yeah, I do feel like that for some reason that I don't know why. This is a common complaint I hear, or I don't know if it's complaint, criticism, whatever it may be, but the failure to like keep on top of cases and files, and I don't know, I don't get it. I mean, I get it to some respect that like, okay, you can get busy and some things could but I don't know. I feel like you should be checking in on everything, on a consistent basis.
I think when it comes to at least case assessments, I feel like some firms or some attorneys feel not comfortable providing an overall assessment on a claim that that has just started. They don't want to be wrong, even though at any point in time, we can always reevaluate the claim. Discovery could change the complete analysis. And I just think that sometimes attorneys can be just nervous to provide information and then later have to come back and say, I was wrong.
Yeah.
Which, that happens, things change, cases evolve.
Yeah. And also, I think the idea should be more so like, okay, not that you were wrong, but new information arise that changed the prior assessment, and that's okay. New information arises all the time.
Right.
But I agree. I think early on you should be able to be like, okay, is this one, is this a mediation matter? Is this a risk transfers or someone else we can transfer the risk to? Like that, you should be able to know that within the first 45 days what your options may be to move it, and not just kick the can down the road because you need to kick the can down the road. And one thing that we had spoke about too is we touched on your feelings as to younger, like green attorneys working on files and getting their experience. And I think there's two perspectives on it. Like, you need to give younger attorneys experience, otherwise they're never going to be old attorneys with experience. But it's hard from a claims manager perspective, because let's face it, like younger attorneys might spin their wheels a little bit more and, kind of might fumble around a little bit. So, what are, your thoughts on, having a greener attorney, kind of take the reins on a file, or does it just depend?
I agree with you that, younger attorneys do need to be provided with experience. I don't have any problems working with younger attorneys. The only problems that really arise, I feel, is when they are spinning their wheels and are billing excessively because of that, when we have to think of the insured's interest as well. The billing has to be appropriately done. So if it takes that associate a little bit longer to do something that would probably do they're going to have to, we're going to have an awkward conversation when the bills are reviewed, and especially if it's with a carrier that has a billing system where line items will be cut.
Yes, we all love those. You always love when those come back. You're like, oh, all right, like let's see what's going on here. But I do think there's something to be said about giving younger attorneys the opportunities, and I appreciated it as a younger attorney. I needed that experience. I needed to do that work, but I also needed someone to kind of guide me along the way, so there'd be less spinning of the wheels. But also there is something to be said about spinning your wheels. Not necessarily the client has to pay for your wheel spin, but that during those times, and you probably remember this too, during those times that you're trying to figure it out, it's a very important, critical thinking process. And, while it might take a younger attorney much longer to figure it out, that critical thinking, I think, is very important for their growth. So it just has to be a balance between what, you probably can't bill for all of that time that they're figuring out, but the process of figuring it out, I think, is really important.
I agree, especially when you get the foundation of having that thought process. When you come across, a novel claim, you can already have the experience to kind of, mentally evaluate it and see, like strengths and arguments, because sometimes that happens where you've never seen something like this, and you have to take a different approach than you would take from, other, like your run of the mill, lawsuits.
Yeah. And don't we all love the novel claim, the one that you haven't seen? Like those always get me a little excited, because you're like, oh, this is something new. Like there's new stuff to dig into and find out about and research. Like, that's what makes our jobs interesting, is when you get different things all the time. It's not always the same. So I embrace those moments, even though, there is some extra thought that has to go into them.
I agree.
So, but one thing, we had talked about though, is going with the experience of younger attorneys is trial experience. And it's just a problem I think we're seeing across the board, is that these things don't go to trial as much anymore. So then people aren't getting that trial experience. And, so is that something like prior trial experience? Is it something that you really look at to be like, okay, like, I really like this attorney because they have X, Y, and Z of trial experience, but also recognizing that we're not seeing a lot of that anymore. So, what are your thoughts on, prior trial experience, given the current scenario that it's not as common as it was, I think, 20 years ago?
Really not as common. Very few things go to trial. I'm trying to think in my experiences, how many claims I've had go to trial. Maybe two, in almost 90. So it's really not a very frequent thing.
Wait, you cut out for a second. How many claims did you have go to trial? I'm curious. I really need to hear the answer.
Two, not a lot.
Yeah, I was like, that sound. At first, I thought you said 90, and I was like, whoa, that's
no. I said in the 9 years I've been handling claims, I think I've only had about two go to trial. So I'm not terribly worried when working with counsel on their trial experience. However, I mean, it's important that attorney recognize if this is going to go to trial, and what their game plan is going to be, because sometimes you have insureds that are just dead set on taking the case to trial. And so you have to make sure the attorney is able to explain the risks of going to trial to the real risks of going to trial to the insured, and just providing all the information. And typically a lot of the firms that I've used while handling claims are larger firms. So if the associate doesn't have trial experience, there's going to be a partner that's also on the case too,
right,
that more likely than not has had trial experience in his or her career.
Yeah.
So I don't think it's necessary to know right up front whether or not it's not necessary to know that or for the attorney to have significant trial experience.
Yeah. One of the aspects I think is, in my opinion, even more important or equally as important as having the actual trial experience is trial preparation experience, because there is because a lot of times you do prepare for trial, or you need to anticipate what you're going to need and that you have to think ahead. And that is something that I think is very valuable, not necessarily, like I went to verdict or whatever it may be, but knowing early on in the case, well, if this were to go to trial, I am going to need this expert, or I'm going to need this. And that is something that is learned with experience. And is something that needs to be, I think, trained for younger attorneys to. That's kind of how you set up your case sometimes, especially if you're doing that early evaluation and you're like, well, I don't know if this is going to be a good one for mediation. So like, let's have a framework that we are really setting this up and lining it up, that this could potentially be a trial case, and having that in your mind when you're working up the claim in the file.
Oh, I completely agree. And especially when, you first get the initial case or claim, the first question I want to know is, can this be resolved on a dispositive motion?
Mm-hmm.
And, you need a realistic answer to that. I mean, I've had attorneys file a motion for summary judgment without consulting with me. And when I ask them what the likelihood is, it's 10%. I'm like, why did you spend $15,000 for the likelihood of being successful at 10%? We can't.
And why did you file a motion without talking to me about it?
Oh, it's more than you think. That firms will go ahead and file, motions without consulting with handlers, which goes back to, what I was saying in the beginning. It's really important that we have trusted counsel on the claim. There's certain firms that I know for a fact know the litigation guidelines, will come and say, will provide me a budget, will say, I need to file a dispositive motion. It's going to cost $10,000. I think we'll be able to, we have a 75% likelihood of success, or if the goal is to knock certain counts out of the lawsuit, for strategy. It's really important to be able to rely on counsel to provide that information at the beginning. And obviously it can change as the case goes by, especially with discovery, but it's really, really important that we have counsel that's keeps us in the loop.
Yeah. And follows the guidelines. I think that should be like, follow the guidelines, people. Like, they're there for a reason. It's not that hard.
I agree.
Yeah, because I was just going to segue into managing outside counsel. And one of my questions was like, what are your pain points? I think we got it. Like, don't go filing motions without talking to your claims handler about it. It's not a good look.
and without talking to the insured about it, because the insured, I mean, if the insured has a large retention, they're going to be paying for a lot of this stuff before,
Yes.
The insurer obligation is triggered. And, if we're talking about a small business owner, he or she might not understand the point of filing a motion for summary judgment. They might just think that, okay, well, this is part of the process, and not realize that maybe it's not a good idea to file one. So it's really important that the insured is also kept in the loop as well, because, that it's their money, it's their livelihood, it's their business. And, they deserve to, be a part of the direction in which, the litigation is headed to.
And I think to that point, it's also very important to understand, and I think this goes without saying, but I apparently we have to say it because I don't think people always get it, understanding the policy at hand. Like, again, if you have an insured with with a SIR, they need to be like really involved. It's their money, and you can't just, move forward, keep them out of the loop. And I think that's a real negative to some to some counsel, that that you're not keeping the insured in the loop and not understanding that, especially in like with self-insured retentions, that they have a say in this, and you have to like inform them and talk to them and explain to them, what you're doing and what the impact is and what the financial impact is, because the dollars are coming out of their pocket as well.
Exactly. And especially it's important when you have a claim that has uncovered loss.
Mm-hmm.
As the handler, I would be speaking with the insured on how we would allocate, covered loss versus uncovered loss. But it's important that defense counsel also knows that there's an allocation in place. They don't need to know the specifics, because obviously that could create a conflict if we start getting too much, if counsel starts getting too much into coverage. But, if they know for a fact that, a certain amount of counts in a lawsuit aren't covered, that the insured is going to have to, pay that out of pocket, it's important for them to know that as well.
Yes.
And so I think it's also important for them to know, like, just general things that are normally not covered in a policy. For example, like a wage and hour claim. I don't know any insurers that provide indemnity coverage for wage and hour, but they'll provide, depending on the policy language of defense. It's important for counsel to know that.
Yes, absolutely. Continuing on that though, we know what you're not looking for with counsel, but what are some traits with outside counsel as a claims manager that you applaud and, you really seek out in your, attorney partnerships in your claims?
Timely budgets, timely case assessments, just making sure that I'm CC'd on correspondence with the insured, that I'm kept, when they keep me in the loop of like all settlement discussions, because you'd be surprised how many settlement discussions can occur. And I just find out when they need money.
See, that's like, I think that's also a big like red flag. Like, I don't know, something I learned rightfully so very early on is you can't offer money you don't have.
Exactly. But there's, go ahead.
No, I was gonna say there are certain nuances, like certainly there's conversations you can have with counsel, and they could say like, oh, we're looking for this, and you could be like, okay, like I don't have anything, but if I were able to get X, would that be something that you could entertain? So you're not promising anything. You're not saying I haven't, and then go back to, hey, I had this conversation with counsel. Like we were talking about the case. We were, I was pushing them on what their bottom line number is. And, they said if we were to bring X, they would settle for that X. Is that a possibility for us? Like that happens all the time, but that's not that's not actually trying to resolve a case without the authority to resolve it. You're kind of help the resolution process. I mean, otherwise it's malpractice.
It gets tricky because, every carrier is different. Some carriers will take an offer without making an offer without consent as setting the floor, and that could really affect the insured self-insured retention. Other carriers have policy language that if it's going to be resolved within the retention, they don't need to consult with the insurer. So it's really important that counsel knows exactly what he or she can offer.
Yes, yeah, and if they have they have to have approval for that from the insured. And
keeping with getting authority, I think it's also extremely important that it's recognized that handlers have authority based on their experience, and not all handlers have the same authority level. And so if counsel's coming to me asking me, saying we need $1 million, that's going to have to go way above my head, and that takes time, to explain why we need that money and the strengths and weaknesses of the case. So if I'm not timely notified of a large settlement demand or valuation, it can delay getting anything approved, because it has to go through, there's steps that have to be taken in order to secure that authority.
Yeah. And that's another huge pet peeve I hear a lot though too, is not giving enough notice to to your claims managers or your claims partners in anticipation of a settlement event, and again, like, and I think it's a lack of understanding of those processes and procedures that your carrier needs to go through, and or your adjuster needs to go through with the carrier in order to get the appropriate funds. And like, you might have settlement authority without talking to a manager or whoever for $50,000, but in order to get $125,000, you might need to go to 2 extra people, and there might be roundtables. It's going to take a few weeks, and this is why if you have a mediation on X date, look at the guidelines.
Mhm.
Or if it's not in the guidelines, just ask. Say, hey, Melissa, I know we have this mediation. When do you need my pre-mediation report so you can put your ducks in a row so we can come to this mediation and try to resolve it?
Exactly. There's nothing worse than getting a pre-mediation report 2 days before mediation, and they're asking for a lot of money.
Right. Right. And it's just not a good look either. Like,
Yeah.
if I were you and I got that report 2 days before, I'd be like, oh, okay, what's going on here? And like, sometimes there might be some other circumstances. Maybe you talked about it. Maybe there was something else going on that you said, okay, that's fine.
Mhm.
But typically speaking, most carriers need 30 plus days in anticipation of a settlement event in order to get the proper authority.
Yes.
And I mean, maybe it was, sometimes there's situations where maybe you just schedule that mediation a week ahead of time. Like, you got an opening with a mediator and they got you in a cancellation spot. So it was a quick thing. That's a different scenario, but
Yeah. I mean, yeah, there's always, exceptions to,
to the rule. Yeah.
to the rule. I mean, I would never fault somebody if we were wanting a specific mediator and they were booked up and all of a sudden there was an opening and we had to rush. I mean, that's just part of life. Unexpected things
Yes.
happen. But when it becomes habitual on a regular basis, it
Yes.
can be problematic.
Yeah, because I imagine you can't help but question in that scenario being like, okay, so what's going on here? Like, do you have too much on your plate? Are you just poor at managing your plate? Or are you like lazy? Like, I'm sure in your mind you're going through all these things. Like, what's going on here? Like, why isn't my counsel getting
Yeah.
me these things timely?
I never really think that people are lazy. I just think that, I just think
Okay,
that,
I put words in
people
your
are
mouth. I
busy.
sometimes think that.
I think people get busy. And I also think it's like you said that sometimes it's not always known the process in which handlers have to go to secure authority when it's outside of our authority.
Yeah.
I very much appreciate when I get a case assessment from counsel, and in the case assessment, they give me a settlement value, and then they also give me a total exposure value, because then I have time to put the money up and make sure that the reserves are adequate. And so if I get an initial report, I can have the reserve set pretty quickly, and if an emergency happens where I have to get authority right away, at least the money's up on the file, and
Yeah.
I don't have to. It's a lot easier to do.
Yeah. And I think that the idea of reserves, again, I think is something that a lot of particularly younger attorneys don't understand what reserves mean. I didn't understand it, way back when didn't understand what reserves meant and with the significance. I remember getting those claim files and seeing like the pre-suit claim and seeing the reserves. And I had no true understanding of what that meant. It took me time to figure out. No one told me either. I just had to figure it out, but it's so important to understand. So yeah, one thing that you and I had talked about though a while back is, the struggles that, we both have, being a professional woman and trying to push our careers forward, but also like we're mothers and you have kids, and, add the working from home and hybrid and all that into it. Like, some things it makes life easier, but then it also makes things a lot more difficult because, things all kind of blend together. So, how have you managed to balance like this all encompassing world that like, our homes are our offices, and, kids are around and they're not around. I mean, it's crazy. So, how have you managed to juggle that?
Well, I think the pandemic taught me definitely it does take a village. that I cannot do it all on my own. I frequently use my mother to help with my kids, to pick them up from school, um, and whatnot. And then also, I think with the remote working has really helped being able to use like flex hours. You know, I'm a very early riser, so I can work if I have to do something with the kids in the afternoon, I can get up really early and work, and then, just try to flex my hours as much as possible. But I definitely learned that I have to utilize asking people for help and not assume that I can do all of it because it's just impossible.
Yes. Yeah, I feel you. I'm not very good on the asking help part, but I feel I feel you on it. But I find it's been really important that like I look back and I kind of so happy that now I can give to my kids, like I am home when they come home from school, and I try to like take that time to put my work to the side for that time when they're doing homework, and like I'm asking about their day, because you know I hope at least they'll look fondly back on that. And to say it's always perfect, no, there's some days that I'm still there on my computer and I'm like, okay, I can't really chat with you right now, but I'm trying to make a more conscious effort to be more present when they come home from school, so they can dump their day on me. And I actually have the ability to be able to push it to the side for a little bit and be there for them. But yeah, like you said, like the flexible scheduling allows, again, for like you to be more present. If you go bring to sports practice or there's a game or whatever it is, like you can be there at those things a little bit easier than I think it used to be.
Yeah, definitely.
And also, I mean, in claims, the work, the remote working and work from home environment has been something that it's been pretty common in claims like well before the pandemic. It's just much more prevalent with everybody, which I think is great, even though it can have some struggles to it. But having said that, though, how do what, other than waking up early, are there any things that you do to like make sure you carve out some time for yourself, so that you're you're more present and you're able to like be present at work and then also present at home?
I mean, my life took a very unexpected turn. I ended up filing for divorce, and in that process, I split my time with my kid's father, and they're with me, and it really allows me when they're with him to be uninterrupted. I can use that time to work. I can use that time to rest. I can do a self-care day, depending, on what's going on in my life. And that actually, even though unfortunately my marriage ended, you know, it really, it really has freed up a lot of my time to not have the kids constantly, and I'm able to like focus on myself or my job or, my mental health. And I think the pandemic has really taught us that, mental health is just as important as your physical health.
Yeah. And also with that, then, when you're devoting your time to yourself and your work, when you don't have your kids, like then you have extra, you don't feel so pulled towards the work when your kids are with you, so you can focus on them. And and one thing I wanted to touch on too, is you recently had a career pivot, which career pivots are career pivots. But I didn't want to close up this podcast without being able to showcase you and your experience, but also like what are you looking for in during this career pivot? What is your ideal job, or like what do you see yourself that you're like, this is what I would, if I were to pick what I want to do, this is what I want to do?
I have been doing EPL for pretty much my whole career. I would be really interested to learn a new line. Cyber is huge right now.
It is.
Maybe learning stuff about underwriting. I think it's really important for handlers to understand the underwriting process and vice versa. So I would really love to learn, something like, learn exactly what goes into writing policies. Ultimately, I mean, ultimate career goal, I'd like to get into a position where, maybe I can manage a team, and provide them with guidance. I think I've had, a lot of different life experiences, professionally and personally, that I can relate to other people with, and help them on their journey as well.
Yeah. And I love the idea of pivoting to learning something new. Because like, let's face it, like we're not old ladies.
Right.
There's still room to learn and to grow, and find another area and learn, like really dive in and learn that. And especially when it's like growing areas like cyber, there's
Mhm.
so much room to grow.
Yeah, I mean, coverage is so vast. It's just it's really interesting, and it's so much of it is shades of gray. It's a lot. There's a lot of interpretation when it comes to reading policy and contractual language.
Yeah.
And so it's just it's really great that there are many avenues to explore in insurance. You can do cyber and D&O, E&O, move over to casualty. There's so many options in insurance that I really do like. And I'm hoping to like get a new experience. Probably stay in financial lines, but I wouldn't put anything down.
Well, I encourage any of my listeners listening that, if you have a position, or reach out to Melissa, start a chat,
Oh, thank
and
you.
see if it's a good fit for you and for everybody. I encourage anyone tuning in, if they think there's a space for you at their organization, that I
Oh, thanks,
encourage them to
Megan.
contact you. So before we close up, if you were going back to, what now about, practicing, going through the practice of law, and then going on to the claims side, what advice would you give to someone who's considering law school? And what advice would you give them about one going, and, some tips as to what to do while they're there to help build their appeal when they graduate as to job prospects?
Um, I would advise younger people to know that, it's okay to change your path. We talked about earlier that, you thought you were going to be a patent attorney. I thought I was going to do international law, and, our lives took us into different places, career wise. And it's okay if your goal, it's okay if you get into, I really love law, but I don't necessarily know if I want to practice. Or if you decide to just go right into like insurance, and then you decide you do want to practice. I mean, there's so many options available to
Yeah.
one specific role. Hey, if things don't work out the way that you thought they would, because they will eventually work out.
Yes. Yeah. I like say this to like my niece, my nephew, who are like, one's in college, the other's applying to college. I'm like, just because where you start, it doesn't mean that's where you finish. Like you have to be ready to, like, things change, you pivot, like I thought I was going to go to med school, and here I am, Life takes turns. It's how you embrace them. Well, Melissa, I really appreciate, you taking out the time to chat with me today. I'm so glad we circled back after, a few month hiatus. And, again, I appreciate you taking the time and sharing your journey and your story and where you've been and where you're going. So thank you so much.
Thank you so much for having me.
You're very welcome. And for our listeners out there, of course, if you like what you hear, please like and subscribe to the Defense Never Rests Apple Podcasts. And you can also find us at the Defense Never Rests on YouTube. Thank you.